Hey everyone, I wanted to talk to you today about telemarketing laws for real estate agents. I know this might be one of the most boring topics on the planet. However, we had an agent who accidentally texted someone on the do not call list, sent 2 text messages, cost $175,000. We do not want that to happen to you, so we're going to teach you how to avoid that. So watch this webinar by some attorneys who helped us through that process.
But with that, let's go ahead and get started. As Chris said, I'm Michelle Schuster. I'm with the law firm of McMurray & Schuster. We're located in Columbus, Ohio. And I got into this business actually from starting at the Ohio Attorney General's office. I was the chief of the consumer protection section in that office when the do not call laws were passing in the early 2000s. And I was lucky enough to be working with Betty Montgomery, who was the chair of the NAG, which is the world's greatest acronym, National Association of Attorneys General. She was the chair of the Consumer Protection Committee. And so in that role, I got to work with all of the other state AG's offices in passing their do not call laws, and also the FCC and FTC, and have maintained close relations with those offices. So naturally, when I got out of the AG's office and started working for Big Law, I was requested by a number of large and small companies to help them start to comply with these do not call laws. And that eventually led to me being hired by the industry association that represents contact centers. And so, as I said, well, I didn't set out to be a telemarketing attorney. It's where I've landed. And our firm primarily works in the consumer protection defense. So all companies that sell direct to consumers and in all 50 states. And my former boss, Betty Montgomery, now works with us, which has been one of the ultimate honors of my entire life. So we will be talking about what I consider a very exciting topic here today, and that's the telemarketing laws. And one of them Chris has already talked about, which is, actually, before I get started, again, for those of you that are joining, we are recording this. Also, I just want to make sure that everybody understands, I'm not providing you with legal advice. I'm giving you an overview of the topic. If you do have questions, you can go through Chris or give me a call. Always happy to help. And this is definitely an area where an ounce of prevention is worth a pound of cure. And then also, if you have questions as we're going along, there is a chat function in Teams. Go ahead and type that question. I'll try to catch those as we're going along and answer them. But if not, I'll go back to the chats at the end of the session, and I'll go through and answer those questions. And if I don't get to yours, we can stay on a little bit longer, or I can email you. So with that, let's get started. All right, so here's the agenda. Our goal is to provide a high-level overview. Here, let me switch my camera real quick. There we go. So I look a little tilted there. And you get to see what happens in the back of all attorneys' offices. I have 2 sets of golf clubs, a mirror, and jackets for court.
Nice.
Hold on, it's still admitting people. But anyway, so the goal of this hour is to provide you with a high-level overview of the highest level risk items in the telemarketing world. And when I say telemarketing, we're also talking about text messages. So I'm going to default to using the term calls, so I don't have to say calls and text throughout the presentation. But the government has determined that a text message is the same as a telephone call with regard to these laws. And the primary areas that we look to when we're talking about telemarketing are the first 2 laws on the list, which are federal laws, which are the TCPA, Telephone Consumer Protection Act, and the Telemarketing Sales Rule. Also, we're going to be talking about state telemarketing laws. So with that, let's go ahead and dive in. All right, so the TCPA and the TSR, and I'm going to use those acronyms a lot throughout this presentation, those are the federal laws that cover telephone calls. And they primarily became noticed by businesses back in the early 2000s, as I was mentioning, when the do not call provisions were enacted. And so basically what the TCPA covers is all calls and texts to cell phones, any pre-recorded messages, whether that's to a cell phone or to a landline. It's also got provisions about advertising faxes and We probably get a new fax case in once a month. I'm always surprised to learn that businesses are still faxing, but they are. Also, do not call lists, and there are other rules, and we're going to talk about all of those in a moment in the presentation. The interesting thing about the TCPA, which is different than most of the other telemarketing laws, is that it applies, some of the provisions apply to business calls as well. So we'll talk about those as well. Also, if there are calls to a cell phone or certain types of pre-recorded messages, even if they're not marketing calls, they can be covered by the TCPA. The reason this is such a problematic statute and why it's so important to follow is that if the FCC brings an enforcement action, the violations are $16,000 per violation, and that's per call. Then on the private right of action side, penalties can be $500 to $1,500 per violation. And again, that's per call. So as you can imagine, as you make numerous calls, especially if you're getting involved in some type of lead generation campaign where you've gotten a bunch of telephone numbers and you're sending those calls out through some type of agency or through a pre-recorded message, those numbers can increase very quickly.
4 Ps, a two, and 2 rolls.
All right, I'm just going to go ahead and mute everybody. There's strict liability for anybody who makes the call. So that's if you're dialing those telephone numbers or if you're running the equipment that's placing those telephone numbers, then you have automatic liability. But there can also be vicarious liability if those calls are seen as being made on behalf of somebody else. For instance, in a situation like this brokerage, it has been determined in several cases that real estate agents are the agents of the brokers under which they work. Therefore, there could be liability for the brokers that real estate agents are working with. So it's not just you, it's a larger universe that you have to worry about if you're placing telephone calls. Also, this isn't an isolated event that TCPA litigation is initiated. It's actually the third most common type of lawsuit filed in federal court. I know you might find that hard to believe, but it's right behind Fair Debt Collection Practices Act and also the federal collections law. Lastly, I just want to say that the reason that we're having this today and the reason that Chris thought this was so important that we provide this education and make this video available is because real estate agents have become a significant target for TCPA plaintiffs' attorneys. And for plaintiffs' attorneys, this is a very lucrative business. I mean, if they find somebody who's received a couple of phone calls, the penalties for the consumer, they range from $500 to $1,500. But what happens is they'll threaten to initiate a class action lawsuit, which means that it's just not that single person that the attorney is representing, but it's everybody who a phone call was made to that the attorney would try to form a class action to sue under. And then we get into those multipliers. For every phone number that's called, that's a potential class member, and that multiplier for the $500 to $1,500 penalty per call goes high very, very quickly. In reality, what you see with these plaintiffs' attorneys, and so you understand the motivation, is that they find a representative class member, they determine how many phone calls were made, they do the math, they make a demand, and then they look to settle those demands for something very significantly less than the multiple millions of dollars that the demands usually end up being, or the penalties that could be charged actually end up being. And the representative plaintiff, that means the client, would get probably somewhere between, I don't know, $2,000 to $10,000 or $15,000, depending upon how many calls they received, and the attorney will get closer to $100,000 to $200,000 for each case. So understand that you are a target, understand that there are plaintiffs' attorneys out there that are trying very hard to find as many of these cases as they can so that they can go out and build their new houses with the proceeds. And the unfortunate reality is that most businesses are put into a position that they have to settle these, because when you have multipliers of $500 to $1,500 per call, and you're looking usually at thousands of calls, and sometimes even tens of thousands of calls, the penalties quickly get larger than calculators will calculate. So that's kind of our warning as we get started on this journey. All right, so there's also another regulation, the telemarketing sales rule, also on the federal level, where the TCPA is enforced by the FCC and has a private right of action. The TSR is enforced by the Federal Trade Commission. It has most of the same provisions as the TCPA, except that it has no private right of action. So as far as the TSR goes, we're only primarily worried about the FTC bringing a cause of action. Generally, those are only brought by the FTC if they're looking at somebody who's committing some very serious harms and usually involves defrauding consumers. So we're really not overly concerned with that for purposes of the presentation today, but I did want to let you know that there is that provision out there as well. Like the TCPA, it has do not call provisions. It also has caller ID requirements. There are mandatory disclosures. You have to call within certain allowable calling hours, and that's 8 a.m. to 9 p.m. And pre-recorded messages require consent. The penalties for the TSR much higher, and this is not a typo, this is the actual number, $42,530 per violation, that is per call. I'm working with a client that has run into some issues with the FTC, and they've sent a proposed consent order, and yes, that number is in there, $530 for every call that was made. There are certain exemptions for certain types of companies not applicable to us. Those are generally insurance companies, banks, companies that are regulated by the FCC, so common carriers, things like that. There's also state telemarketing laws. Later in the presentation, I've summarized Kentucky, Indiana, and Ohio for you because I figure those are probably the most relevant for your day-to-day jobs. But like the federal telemarketing laws, they also have do not call laws. Ohio does have a telemarketing registration requirement, as does Indiana. We'll talk about that in a minute. They also have prohibitions against calling cell phones or text messages for marketing without consent. They have calling days and times that are allowable, and some of those are more strict than the federal. Again, we'll talk about that. They have disclosure requirements. If you're using a pre-recorded message, it's specifically regulated, also requires that you send a caller ID. And if you're monitoring or recording the telephone call, there are some states that require that you give a disclosure about that. So let's dive into the details. Calls and text to cell phones. I will tell you this is the area that causes the most problems right now for businesses because this is not an intuitive law, which is one of the reasons we're having this session today, so that you can know what is not intuitive, what wouldn't just be known unless you were educated on it, as far as what these laws allow and what they don't allow. So the general rule when you're calling a cell phone is that you have to have consent if you're using an automatic telephone dialing system or an ATDS, or if you're using a pre-recorded voice to call cell phones. Now, just to put some context here so this makes sense, the reason that the TCPA regulates automatic telephone dialing systems is because in 1993, when this law was passed, it was trying to stop what the first telemarketers in the industry were doing, which was basically just getting a dialer, using it to generate either sequential numbers, meaning increasing by an integer of 1 for the last digits with every phone call, or they were just randomly calling phone numbers from the phone book. And as a result of that, what we saw is that telemarketers were tying up all the lines in a police station or all the lines in a hospital or all the lines at the IBM office because those were all sequential telephone numbers. And it caused some significant problems. So that's why when the law was drafted, they were talking about automatic telephone dialing system. I'm not going to go through the history of this with you because it is long and it ended in a Supreme Court case that we were involved in that had a very good decision last April 1st. Called Facebook versus Duguid, but the automatic telephone system, dialing system, is not really a definition we're so concerned about anymore, and I'll explain that to you here in a moment. The other thing I wanted to note is that when we're looking at the telemarketing laws, which are generally those laws that are or those telephone calls that are meant to sell a product or a service or something of that nature, you can have mixed telephone calls. The example I always like to give is you have auto dealers that invite consumers in for customer loyalty or public events where really the true purpose of that event is to get consumers into their dealership to sell cars. And because the intent is to sell cars, the law sees those as telemarketing calls if you're calling to invite those consumers in. Also, for the prohibitions against calls to cell phones without consent, it's not only calls to consumers, it's calls to businesses as well. So if you are calling maybe randomly a campaign to, I don't know, attract more title agencies or something like that. And if the purpose was to get them to recommend you as a realtor, that could be seen as a telemarketing call. It'd be B2B, it'd be the TCPA would be applicable. Just so you're not confused, this definition of ATDS, automatic telephone dialing system, this is what I was talking about when defining ATDS and the type of dialing equipment it was intended to prohibit. So it was equipment that had the capacity to store and produce telephone numbers to be called using a random or sequential number generator and then to dial those numbers. This really isn't much of an issue nowadays. There was a lot of litigation over that word capacity. And there was some litigation that ended it with the Supreme Court case, Facebook versus Dugat, that Facebook was involved in. And the Supreme Court said that the capacity word wasn't really relevant. You have to be actually using that random or sequential number generator to generate the numbers and then to dial them. So, you know, for purposes of ATDS, it's not as big of an issue as it was a year ago. But what you will see is it's really only one of the prongs of the TCPA that we're concerned about. One is, you know, the type of dialing equipment to call cell phones. The other is the do not call regulations. And that's the area where we're seeing the most issues nowadays. So let's talk about non-marketing calls first, because the prohibition against making telephone calls under the TCPA is making them without consent. And there's two levels that you need, two levels of consent that are needed. One is for non-marketing calls, the other is for marketing calls. And so non-marketing calls are those calls that have no intent to sell a product or service, truly are transactional, maybe a reminder that you owe a payment, or to let you know that your dentist appointment is next Tuesday at 9 o'clock, or, you know, something of that nature, truly a non-marketing telephone call. Now, for non-marketing telephone calls, if you're using an ATDS or a pre-recorded message to call a cell phone, you need prior express consent. And the really great thing about this is the TCPA does not define that term. So the FCC has had to come in with rulings to tell us what the term prior express consent means. And so this is actually a good thing for you, because what they have said is if a consumer has given you their cell phone number as a means of contacting them, and you're contacting within the purpose for which they gave you that number. So for instance, let's say that someone is interested in using you as a real estate agent. They've given you their cell phone number to call them. And if you were using a pre-recorded message or an ATDS, and you were really just calling them back to set up a meeting or something like that, it could be seen as a non-marketing call. And because they've given you their telephone number, their cell phone number as a means of contacting them, you have consent to make that telephone number or make that telephone call. Again, we're only worried about pre-recorded messages here, or if you're using an ATDS. We'll get to the do not call laws in a minute, but if they've provided their cell phone number, if it's a non-marketing call, then you have consent to make that telephone call. Again, if you guys have questions as we're going along, don't hesitate to put those into the chat. All right, so some of the common problems we see with express consent issues is that there's no documentation. So it's always best if somebody has given you their cell phone number as a means of contacting them. If you use a forum, I know you guys use lots of forums as you're meeting with potential consumers who want to hire you for real estate services. So always best if you can document them, or if you know, you're putting these in your contact system, put a little note in the note saying gave me their cell phone number on such and such date at the Rotary meeting or something like that. That type of documentation will go a long way. Also, one of the problems we see with express consent is that we make phone calls outside of the scope of consent. So let's say they've given you their telephone number because you're a real estate agent, and they want you to contact them, but you're also selling some type of, I don't know, Avon. I don't even know if they still sell Avon or something like that. But if you're calling them now and sending pre-recorded messages to sell Avon, that would be outside of the scope of the real estate agency that they would have given you that consent for. Also, an issue we see frequently is reassigned numbers. So if somebody's given you their telephone number and then they give up their phone number and it's assigned to somebody else, the law has said because you didn't have consent to call the person that number was reassigned to, that you can have liability. So if somebody tells you that you've reached the wrong phone number, you should delete that phone number from your calling database. All right, written consent. This is probably the most important part of this presentation, which is how you can get consent to use a pre-recorded message or an ATDS, or to call and not have to scrub against the do not call lists. And basically, what you have to have is a written agreement that has a signature, and that can be an electronic signature, that identifies the seller to which the consent is being provided. It also includes the telephone number that's giving consent to be called, and it also requires some type of affirmative action. I'm sure you guys have seen these type of written consent disclosures on internet sites that you've gone to that are asking you for information and they want to follow up with a telephone call. You'll see the, by selecting next, you give your consent and electronic signature to receive marketing calls by an ATDS or pre-recorded message. Your consent is not required for purchase, and then they'll have some type of next button that you can continue with. So that's the type of consent that we're talking about. Really important that if you're going to rely on this type of consent for marketing campaigns, that you get it reviewed and approved. Because if your written consent is not accurate, then every subsequent telephone call you make relying on that would be a violation. So we'll want to make sure you get it right. And this is basically what I just went through. So telemarketing calls, either as using an ATDS or with a pre-recorded message, consent not required for purchase, the identity of the seller, and then your signature. Those records should be kept for 4 years, and that's because the statute of limitations is 4 years for the TCPA, and that should be from the last date of the calls for the campaigns that you made. Also, if you're making telemarketing calls, and I just really want to be clear here that, any types of calls that are made to sell products or services or to sign somebody up as a real estate client, those are generally seen as telemarketing calls. So it has a very broad definition. See, Chris, let me get into my chat here. So Chris asked, brokers text our agents every week in an attempt to recruit them to their brokerage. They do this even after agents have asked them to stop. Is that legal? It would depend if they gave consent. We'll assume that they didn't give consent for those types of calls. I think it's likely that these folks are just using their cell phone, so it's not an ATDS. It's also not a pre-recorded message. So those are the things we're running through as far as what triggers the TCPA: a pre-recorded message, an automatic telephone dialing system. And also here, the broker's not trying to sell anything. He's actually trying to buy something. I guess you could say they're selling brokerage services. So that could be a telemarketing call. But here, this is going to be in the context of business to business. So the next thing we're going to talk about after we get beyond the kind of modes and mediums of placing telephone calls is the do not call laws. Because if they're not using a pre-recorded message, if they're not using an ATDS, and they're only making a B2B call, then that's going to fall outside of all of these regulations that we're talking about. So other than them just being slimy, there's probably no telemarketing issue with those types of calls. Insurance companies text the agents every day. Again, this is going to be a business-to-business call. And then can an agent or a homeowner, if they can an agent call a homeowner if they have advertised their number online as for sale by owner? Is this express consent? That is such a great question, and that is something that the courts are taking a look at now. But if this is a consumer that has put their house out on the market and the house is for sale, if the agent's calling because they're interested in purchasing the house, that's not going to fall within, and when I say purchasing the house, that probably for a customer or a client, not the real estate agent, but it could be the real estate agent. But they're looking to purchase something, then that's not going to fall under the definition of telemarketing because they're purchasing. If they're calling because they want to sell their real estate services to the consumer, there has been at least one district court that says that that is telemarketing and that a general listing and the MLS does not constitute consent. And so what that means is you'd have to scrub against the do not call lists. And again, I'm getting ahead of myself here a little bit, but that's what we're going to talk about next is if you're not using an ATDS, you're not using a pre-recorded message, but you are engaging in a consumer telemarketing type of call, then we'll have to scrub against the do not call lists. Also, are there insurance policies for TCPA coverage? There are insurance policies for this. They can be pricey, but if anybody needs a broker, an insurance broker, I have a couple that I refer that do sell this type of insurance. Common written consent issues. And we were just talking about written consent and what's required for written consent. Where we generally run into problems, and this is something I would advise you to be very careful with, is that there are lead generators that will have websites online that would get consumer information, and some of these lead generators just buy consumer information that's for sale out there. And unless the lead, the form that's collecting the information discloses that you are the one that's going to be making the telephone call, so identifying as the seller, the person that's or company that's going to be making the call, that's not consent under the TCPA. Remember, I said that you have to identify the seller. So if you ever are buying a list of leads, be very careful, and that's something that you would definitely want to have your counsel take a look at and make sure that you're not using an ATDS, that you're not using a pre-recorded message, and that you're probably going to have to scrub against the do not call lists, which I tell you probably eliminates about 70% of the telephone numbers that can be called because the national do not call list has gotten so large. All right. Also, if somebody who's given you consent to call them then tells you they don't want to be called anymore, then that means that they're revoking their consent, and then therefore you have to remove them from your calling list. So as soon as they revoke consent, you no longer have consent to call them. If you're using an ATDS or a pre-recorded message, you'd have to have consent to call a cell phone, or you'd have to scrub against a do not call list, which obviously, because they've asked you not to call them, they would be on your internal do not call list. Because we're running a little short, I'm going to skip that. Actually, so let's talk about this for a minute. I was just telling you that, if a consumer makes a request not to be called again, that you have to honor that. What that's called is putting a consumer on your internal do not call list. So every company that makes any type of telemarketing calls to consumers is required to keep an internal do not call list. It's actually a violation of the law if you don't have the internal do not call list. And that would be a list of any consumers or other persons that have asked you not to call them again in the future. Generally, if somebody's making a do not call request, as I've said, we treat that as a revocation of consent as well. If we're talking about text messages, this is the standard opt-out that you see in most text messages, which is the respond with stop to stop receiving text messages. That's the same as a do not call request. So you'd have to honor that, not send any text messages that would be with an ATDS with not a pre-recorded message, because obviously that wouldn't apply, or if it is a marketing text. There are no grace periods, and this is generally a human process to add numbers to an internal do not call list, so there can be errors. It's something you want to be careful with. And there can be multiple accounts with the same phone number, and it would apply to all of those accounts. as well as any affiliated entities. So I would say that if a real estate agent received a do not call request, that should go to the brokerage level as well. All right, so we've talked about do not call laws. And so again, if we're not using an ATDS, if we're not using pre-recorded messages to call a cell phone, or if we're calling landlines only, then the only thing we're worried about is the do not call laws. And basically what the do not call list is, it's that national do not call registry that I'm sure you've heard a lot about on the news. You can sign up for it online. The states all each have their own do not call list as well. There's a handful of them that still maintain their own do not call list, but most of them just default to the federal do not call list for telephone numbers that have their state area codes in it. Ohio, Indiana, and Kentucky all use the national do not call list, so you really only have to worry about one list for them. I'm thinking the overwhelming majority of the calls that you would be making. We already talked about the in-house or the company-specific do not calls, which is the list that you have to keep as a company, and then the national do not call registry. There's also a list of wireless telephone numbers. Some people often ask, how do I know if I'm calling a cell phone? Well, there is a wireless list and a ported wireless list for consumers that have transferred a home telephone number to a cellular telephone number that are both maintained by a company called iConnective. So all of these do not call lists are available to companies. The general rule is that if you're making a telephone call on the, if you're making any type of telephone call that's a telemarketing call, you are required to, and you don't have consent. So if you're making any type of telephone call that's a telemarketing call to a consumer and you don't have to have consent, you have to scrub against the national do not call registry and also your internal do not call registry. And this applies to lead generation calls. It applies to calls to set up a face-to-face appointment, as frequently will happen with real estate agents. It doesn't apply to B2B calls. And this is, something that we had talked about earlier. The national do not call laws only apply to business to consumer telephone calls. Also, it doesn't apply to calls for charitable donations. So we really are talking about telemarketing calls here to consumers when we're talking about the do not call requirements. So the requirement is, as I said, before you make any telemarketing calls, you have to scrub against the national and applicable state do not call registry, as well as your internal do not call registry. The exceptions are if you have written consent. We talked about what the requirements are for that a little bit earlier. Or if you have an established business relationship. And this is going to apply, I'm assuming, to a lot of the telephone calls, telemarketing calls that you would be making. So what is an established business relationship? Established business relationship in Ohio, and we'll go over the state ones. So I'm just going to give you what Ohio is and the national, is anybody who's a current customer, so somebody that you're currently working with, anybody that you've done business with in the last 18 months, so after you stop doing business, the existing business relationship exemption extends for 18 months, and then anybody who's made an inquiry about your products or services within the last 3 months. All of those are established business relationships. So current customer, did business with them within the last 18 months, or they've made an inquiry within the last 3 months. And if there is that existing business relationship exemption, then you're not required to scrub against the national do not call or the state registries. You will still have to scrub against your internal do not call registry, but not those big ones. Again, we've talked about what it takes to get prior express written consent. I won't go through this again, but understand that that written consent exemption also applies for do not call. This is what I was just explaining to you. 18 months from the last date of purchase or 3 months from the last inquiry. Those are the EBR exemptions. Those EBR exemptions do extend to affiliates or subsidiaries. But what the FTC and the FCC have said they look at is if the companies have a similar name, sell similar products, and the consumer would expect that if they had done business with one of those, that they were doing business with the affiliates and subsidiaries as well. I'd like to use maybe General Motors as an example of that. There's so many different units of General Motors, but if you've done business with one of those, I think most consumers would consider those doing business with the corporate General Motors, and that EBR exemption would apply to all of those entities. All right, so we've talked about calls to cell phones. We've talked about the do not call list. Now let's talk about some particularities in the law that affect Kentucky and Indiana primarily, that are a little bit different than the standard regulations and most definitely the federal regulations. So in Kentucky, the allowable calling hours for telemarketing calls, whether you have consent or not, is 10 a.m. to 9 p.m. And so that's something to keep in mind. Generally, we're only talking about cold calls here. Those are the ones that are problematic. The folks that you are currently working with that are expecting those phone calls outside of that hour, and most likely you're not selling them anymore. They're transactional calls. We wouldn't be concerned about those Kentucky times. But basically, if you're cold calling, if you're doing any type of telemarketing, then you have to limit that 10 a.m. to 9 p.m. in Kentucky. In Indiana is one of those states that is extremely active in their Attorney General's office when it comes to do not call and robocall enforcement. Because they don't have the 18-month established business relationship or the inquiry DNC exemption. So once somebody has stopped doing business with you in Indiana, then there is no ongoing business relationship that allows you to call without scrubbing the do not call list. Now, of course, consent trumps everything. So if you have consent to call somebody, then you do not have to worry about the do not call lists. You don't have to worry about Indiana's lack of any type of EBR. The do not call list is available just signing up in the FTC's website. The good news for you guys is that while it's approximately $63,000 or $63,000, my gosh, multipliers, right? It's $63 per area code to download the do not call list. And the process for getting the do not call list is you fill out a form on the FTC's website that asks who you are and why you need the do not call list. And then they'll charge you $63 for each area code you have to download. The first 5 area codes are free. So I would suspect that most of you guys are calling within a 5 area code limit. So if you ever were engaging any type of telemarketing, telephone calls, you could probably sign up, get the first 5 free, and it would cover you. Each separate division or subsidiary of a corporation is required to purchase the list separately. It doesn't really apply to you guys. I would anticipate that the brokerage would be able to share the do not call list with the agents. There is a safe harbor if there is a do not call violation that was as a result of an error. What it requires is that you have written policies and procedures for complying with the do not call and telemarketing laws, that you train personnel in those written procedures, kind of like what we're doing today, but it could even be a much more simplistic training session. You also have to keep that internal do not call list of consumers that have requested not to be called again. And then you have to download that list once every 30 days to make sure that you're keeping your do not call list up to date. And then you have to have a way of monitoring those policies and procedures to comply. And then if there is a subsequent error or a subsequent issue, then it was a result of an error. So this is a litigation defense. It doesn't keep somebody from suing you, but it would give you a litigation defense to say that there should be a safe harbor for any violation. As far as state registration and bonding goes, there are a number of states that require bonding and registration for telemarketing. In Indiana, it only applies to sellers, which is defined as someone who makes false representations. And there are other non-relevant factors to what all of you on the phone would be doing for telemarketing. And I don't think that any of you are going to be making false representations over the telephone, so I don't think you'd be required to register in Indiana. Kentucky has no registration requirements, and Ohio exempts licensed real estate agents and salespersons. So this is the good news from today's presentation. None of you have to register as a telemarketer in the 3 states that you're primarily working in. Pre-recorded messages. You know what, we're going to skip the FTC rules because I don't think we're going to be too concerned with that. We're mostly concerned with the TCPA, and their regulations largely regulate the FTC's TSR. But the rule is, as we've said, for telemarketing messages, you have to have written consent to call cell phones or residential telephone numbers using a pre-recorded message. Also, that pre-recorded message has to provide an automated opt-out mechanism, which basically means that during the beginning of the pre-recorded message, it would say to be added to our do not call list, press 1, or to be added to our do not call list, call, and then it provides a, I'm sorry, it's got to be automated. So it's got to be a press 1, or it's something that's got to do it automatically without them having to take any future action. If it's a non-telemarketing message that you're using a pre-recorded message for, then you just have to have the prior express consent. And remember, we talked about that as a person provides you with their telephone number to call them. Then for those non-telemarketing messages, you only need that prior express consent. Also, for pre-recorded messages, there is no consent required for calls to landlines that are non-marketing. So you can leave pre-recorded messages on landlines as long as they aren't marketing. And unfortunately, I hate to tell you guys this as we run into midterm elections, but political calls are exempt from all of these laws. I start getting that question right about now. And political calls are not considered telemarketing calls and aren't regulated by telemarketing laws. We've already talked about the allowable calling times. On the federal level, it's 8 a.m. to 9 p.m. for telemarketing calls. Kentucky is more restrictive, 10 a.m. to 9 p.m., so a little bit less time, but probably more reasonable times to be making a telephone call. I often get the question, you know, what do I need to follow? Do I need to follow the area code or the address of the person I'm calling? And the answer to that question is both. There are cases out there that said you can primarily rely on the area code, but if you have information about the address where someone lives, then you are required to also honor that address as to where they live. So if you have definitive source of address or area code and know that that's applicable to where that consumer is, then that's what you would have to follow for calling time exemptions or restrictions. Caller ID. We don't really need a slide on that because I'm assuming that most of you would be calling using either your cell phone or a landline, and that's going to automatically transmit a caller ID. But just so you know, if you are ever working with a marketing company, they're required to transmit a caller ID, and they can't do anything to block that caller ID from being sent. You can use a local caller ID, provided that local caller ID is something that can be used to determine who placed that call. But there are caller ID laws, so if you do work with any type of marketing company, make sure they're aware of the requirements for transmitting an accurate caller ID. So I don't think are going to worry about credit cards. This is something that I wanted to bring to your attention, though, with regard to Kentucky. Kentucky is a little bit odd in that they have something that's called a permission to continue rule. So if you were calling somebody, let's say you were calling somebody to find out because you saw a for sale by owner sign and you wanted to call to see if they wanted to use you as their listing agent, you'd have to start by saying, hi, this is Michelle. I'm calling about becoming a real estate agent. Is it all right if I continue? You literally have to say, is it all right if I can continue? Or do I have permission to continue? And then they have to say yes. If they say no, then you have to terminate the telephone call. Also, you have to inquire as to whether they're 18 years or older. If you have information that they are, then you can probably rely on that. Otherwise, you have to ask if they are over 18. And again, unless you get an affirmative response, then you can't continue the call. And that brings us to the end, except that we have lots of time for questions now. So I know that we had some questions early on. Are there any other questions? And this could even be about consumer protection laws. But primarily, obviously, we're talking about telemarketing laws. Anybody have any questions about texts or calls, or have I so thoroughly explained it or so thoroughly confused you that you're speechless? All right, let's see. I think we have a
Hi,
new
Michelle. I
message
do
here.
have a question. Do you mind if do I need to type it in the chat?
No. Go ahead. Yeah, no, we're
Okay.
available now.
I guess,
Chris, do you want me to turn off the recording now, or do you want to keep it on? Yes.
Yeah, I would say let's keep the recording on because
You
some
got
of the
it.
questions will be the what's relevant to our agents.
Yeah, absolutely. Okay, go ahead.
Okay, great. Thank you. So this is a lot, and of course, you know, the penalty
It is a lot.
is a lot as well. So, you know, with agents, I think it's important to understand in our marketing. I think it's something that we shouldn't be scared of doing.
Yes.
However, is it beneficial to just not solicit, quote unquote, business, or I don't know, what would be your recommendations on when we are soliciting business? Should we check on a monthly basis, a quarterly basis, or what would you suggest?
So tell me about like the types of things that you would be doing on a regular basis that it would make you now kind of stop and pause after hearing what we had to say today. Maybe if you could give me some examples, I can talk you through those. So we're talking about.
So I'm licensed in about 7 states, and so I know, as you have stated, a lot of the states have different requirements, and so there are companies that essentially aren't our clients, but we do have their contact information, and we do put them in our CRM system, our database, and they will receive, you know, monthly newsletters or any updates, things of that nature. So what would be your recommendations? Do we still need to ask permission, or should we set a timeline on our calendars of checking to see if we do have permission to continue to send those emails and things like that?
Yeah. So first, the good news. So if we're talking about newsletters, I'm assuming we're generally talking about emails. And emails are regulated by CAN spam, and there is no private right of action. So let's just start with the good news there. And what you have to do to comply with CAN spam, so you don't get into trouble with any of the regulators, is just to have an accurate from line. So you can't try to cover up who's actually sending the email or be deceptive about who's sending the email. So have an actual from line, and then you have to allow an opt out from receiving future emails for 30 days. And so that's that automatic opt-out or the unsubscribe you see at the bottom of a lot of these emails. And that's only for unsolicited emails. So, you know, the first thing you would say is those people that have signed up for our newsletter, if they signed themselves up, those aren't going to be unsolicited. If you sign them up, then they would be unsolicited, and you have to honor those unsubscribes. But email is a very low area of risk. Generally, the only thing we're really concerned about is those two things I just said, and then making sure everything that we've got in the email is accurate. Now, let's just say that we were instead sending those newsletters by text message. So let's say this was going to be a link that took you to the newsletter. Then we're assuming we're not using an automatic telephone dialing system because you have a list here. It's not random or sequential. You're actually sending a list to people that have provided their telephone number. Now, if you have, I would consider this newsletter probably as a telemarketing call or a telemarketing text to be on the safe side. But we could probably make a defendable position if it wasn't, after we took a look at it. But let's just say that it is it's determined to be a telemarketing text, because the purpose of sending this newsletter is so they'll retain you as an agent in the future. Therefore, you're trying to sell something as a telemarketing text. So we know that if we're sending telemarketing text to a cell phone and we're not using an ATDS, then we don't need special consent for that. So then we look at the do not call regulations. And so it would be, has this person made an inquiry in the last 3 months, or have they worked with us in the last 18 months? If so, then we have the inquiry exemption. But the best thing is, and I always recommend this, when you are meeting people, when you're at those places where you're getting a multitude of contact information, if you can have, an information form that they're providing you with their information, and you have that consent language at the bottom, you're always going to have consent. So,
Okay.
if you don't have consent, you'd have to scrub against the do not call. You'd have to scrub against the do not call lists for those cell phone numbers before you could send the text. So send emails or get consent.
Okay, great. And one more other question. And so for our agents, because I'm a principal broker in a few other states as well, for our agents, if we've communicated these concerns or how to proceed properly, how do we protect ourselves as brokers when one of our agents, does something that violates the do not call list?
Yeah, I'd like to know that.
Well, at that point, it's too late. So that's the bad news. This is the good news, though. You can be proactive with this, and what you have to do is, your broker agreements with your agents. Make sure you, outline what they can and can't do, and give them training like this, and have policies and procedures that outline exactly what they can and can't do. And this is why you have to do that, because when you're looking at the law, as I said, you're looking at, the person who actually physically placed the call is the one that has primary liability. And then there's vicarious liability for anybody that person who placed the call is acting as an agent on behalf of. A lot of cases out there now are saying that a real estate agent is an agent of a brokerage. But what you can do to break the agency for purposes of a TCPA claim is to do exactly what I said. Have contracts that prohibit making calls in violation of the TCPA, have policies and procedures in place that prohibit those calls and texts in violation of the TCPA, and then train them on it. And if you catch somebody or become aware of somebody who's violating the TCPA, you have to terminate it immediately. So there are ways that you can fight vicarious liability before it becomes an issue. And again, this is definitely an area where a pound of prevention is worth an ounce of cure. An ounce of cure is worth a pound of prevention. Reverse that.
except for, even if we have all those things in place, we still have to litigate it, right? So we still have to face $250,000 in attorney fees to defend ourselves. Am I right?
So how the interaction happens with plaintiff's attorneys is very different if you have those types of things in place. Because then the plaintiff's attorney, has to establish vicarious liability. But if you have those policies and procedures in place, and you have the contractual provisions, and you're training your folks, and you're not encouraging them to make telemarketing calls or to blow up their sales by dialing every phone number in the phone book, then that interaction with a plaintiff's attorney is going to be very different in the beginning. So they're going to go for an easier case, because Chris, there are so many companies out there that do this wrong. If you start following the TCPA lawsuits, it's out of control.
Well, the big concern I have with the list that you had for the safe harbor is maintaining an internal do not call list, because we can't. We're not like a business. We're not like AT&T, where we'll put 1,000 people out there making, and we tell them who to call, and our agents come up with their own people to call, and we're completely decentralized. We don't have a database. Every agent has their own database, and it's not a centralized thing. And then if someone up in Swanton, Ohio, an agent is told not to call, how do I know about that? If I have to hope the agent tells me that. So it just seems like there's so much liability that it's impossible to actually do.
Yeah. So again, so if we're talking about risk, that's a lower risk item, and this is why. So if one person claims that they made a do not call request, then you have one person in litigation. In order to establish everybody else that's made a do not call request, you'd have to make an individual inquiry to every person that's ever received a phone call. And there's something called a fail-safe class that's that's not will not be certified by the court. And a fail-safe class means that you have to show that the law was violated in order for them to be in the class. And that's what you would have to do for the type of situation where you're talking about. So it's a low risk item with the type of setup that you guys have. But having said that, Chris, it's a good idea, to set up a brokerage do not call list.
Yeah,
so we
I
can
think
talk about
that's
that later.
what, gets me caught up is, you have agents that they're independent contractors, so they run their business, as they see fit.
Yeah.
And if we put in our policies and procedures, you need to check the do not call list. You need to ensure that they're not on the do not call list. But in the event that they contact someone, even accidentally on the do not call list, we could still potentially be liable, or like Chris mentioned, have to, hire an attorney to litigate the situation. And so I don't know if you've ever seen a brokerage that puts in there, you cannot solicit, any customers at all, because that kind of alleviates the whole situation. So if you solicit, any customers, then that's kind of a case of, well, you really can't get any additional business, but also it's kind of taking me out of the equation because I told you couldn't solicit any customers. And that's a huge lawsuit, and it is a lot of litigation that you would have to do on that situation. So I don't know. That's a tough one.
Well, let me just be really clear about this. I am not telling you not to solicit. I am telling you to solicit until you're, until your heart's content and as often and frequently as you can. What I'm telling you is, if you're going to engage in some type of telemarketing campaign, so you're going to buy a list of telephone numbers and randomly call the ones that are in your area code, that list that you're going to be calling from, and you're going to be sending pre-recorded messages, and these are solicitations. You're going to want to stop and pause, and you're going to want to make sure your agents stop and pause. And so, what I highly recommend, and, of course, we're happy to help you with this, is to put together a little list that just says, this is a red light for advertising, or a green light, or, a yellow light, whatever. And, the red light is if you're using a pre-recorded message, or if you're, working with a marketer that's going to be dialing from a list that you didn't collect, phone numbers that you didn't collect. So how often do you think that happens with your agency? I just don't know what's an outlier as opposed to what's current, or what's something that happens pretty regularly.
What's your question?
So I mean, how many of the agents on the phone would engage in, hiring a telemarketer to start placing a large amount of telephone calls for them? Is that fairly uncommon?
Just a few agents do that.
Yeah, so those are the ones we want to focus on. And so, if I wouldn't tell people they can't do it, I would just tell them that they have to make sure that they understand the rules. And it's, that this is our little campaign initiation list. If you're going to, if you're going to use these companies to place these telemarketing calls on a bulk basis, you need to make sure you're doing these things.
Let me ask you this way, because I think we've all gotten completely terrified over the last hour just to hear everything we can't do. So let's just say, it's important to be able to contact expired listings somehow, but Michelle, if we hired you at Plum Tree, and you were one of our realtors, and you wanted to contact an expired listing, is there any way to do it? Just go knock on their door, or is there any way to do it through a phone? What's the legal way to contact them?
So I'd tell you to call a law firm first and get some legal advice. But if I was a real estate agent, not an attorney providing advice, I would scrub the telephone number against the do not call list and make sure that it's not on there. If it's not on there, then you can reach out to them.
Can
If
you
it's
do
on
it
the
through?
do not call list, then
Stay away.
you'd have to use an email or send a regular mail snail
Okay.
mail piece, or some other way other than a telephone.
One other thing is a ringless voicemail. Can that be
Yeah,
sent? Can that be sent to someone if they're not on the do not call list?
that's considered a pre-recorded message.
So that would be a
So
no, right?
yeah, that's something that
Unless
we've
written
debated for.
consent. So you
Unless
need
written, look at you.
written
That's right.
consent,
Written
right?
consent. That's right. For a pre-recorded message.
So
Yes.
close those accounts, everyone, if you have those accounts, because nobody's getting written consent. So I mean, it's impossible to get written consent from an expired listing or a for sale
Yeah.
by owner.
Yeah.
So if you have a Sly Broadcast account, you might as well close that account.
Yeah.
Chris, I have a question. Vince Starpole here. Can you
Go
hear
right
me?
ahead. Yep, you're on, buddy.
So let's say somebody's driving around a neighborhood and sees one of our signs with my name on it on a house, calls to see if it's available, and it's not. It's in contract. Do I have to go through consent and scrub lists to call him back and offer him my services?
So I think it's pretty safe to consider that an inquiry call. And again, this is a low risk thing because these are one-offs. The things that are high risk are the things that we are doing repetitively, like buying a list and using ringless voicemail, or buying a list and calling without scrubbing against the do not call list. So I think you would probably have an argument, Vince. I mean, obviously everything's fact specific, but there's probably an argument that that's an inquiry EBR and you could call them for 3 months.
Okay. Okay, good. Thank you.
Yeah, you're welcome. See, look at that, Chris.
Yeah,
I said
hi.
yes. Maybe, I think I said maybe technically, but that's probably a yes. Yeah. Go ahead.
Yeah, this is Javaria here. I had a question. So we can, the expireds, we can mail them anything? These regulations don't apply to the mail?
That's correct. Or email. You can mail
Oh.
or email.
Gotcha. Thank you.
Hello.
Michelle McBride, I think, did you have your hand up? Or Christina Strickland?
Can you hear me?
I can, yes.
Okay, hi. I have a question. So if somebody's advertising on Zillow, isn't that like putting their phone number out there already?
Yeah, but they're putting their phone number out there to sell their house, not to request real estate agents to call them, to offer real estate services. So this is something that in the last probably year and a half, courts have started to look at and are saying that by putting your house up for sale, you are not inviting real estate agents to offer their real estate agency sale services.
Okay, and one last question. Where do we find this list and where do we pay for, or I'm sorry, where do we get the so many area codes for free?
Yeah, you know what? I can actually probably walk you guys through this real quick. Let me see if I can get this pulled up and share my screen.
Maybe we can come up with some way to share area codes, Chris, since all of us are from different area codes. I don't know.
Yeah, there's got to be a way to systematize it, I would think. Now, I wonder if conversion might automatically do that. If the phone numbers are in conversion, there might be a scrubbing system in there that I need to learn about.
Yeah.
Probably. Okay, National Do Not Call Registry. Here we go. Okay. All right, let me share my screen here. All right, so this is telemarketing.donotcall.gov. And this is a registration page for telemarketers. And so if you wanted to register to get area codes, it gives you the instructions for how to do that. And there's also this FAQ that's very helpful for companies that are interested in downloading the Do Not Call registry. What will happen after you sign up as a new user, you'll get something that's called a subscription access number, or a SAN. And that subscription access number allows you to enter in here as a registered, where are we? Oh, it's not going to let me go back. As a registered user, I'm sorry. So anyway, once you register, you'll get a subscription access number. And then as you go in and download the list, that's when you'll be billed for the list. And that $63 or $73, whatever it is now, that's per area code per year. So that's an annual cost. And for every area code in the United States, it figures out to be a little bit north of $17,000. So this is where you would go. And so if you went through to, this is also excellent. So once you go here, there are so many great resources that you can see. Also, I wanted to be able to get you to the registration page for some reason, though I've navigated away from it, and it will not go back. Oh, here it is. So this is what it'll ask when you are entering the information. So this would be the organization's name, and you'd fill out the information. It's going to ask for an EIN or a social security number. If you're an individual, it gets your telephone number, get your function, which you guys would be a seller. The authorized representative. So this is the one who's primarily going to manage this account. And then what you're going to be using to download the list. But while I'm in here, just because I think that something that I think would be helpful for you as well. So the FTC puts out this publication, and if you have general questions, especially about Do Not Call, the provisions in the TCPA and the TSR for Do Not Call are almost exactly the same. And the differences aren't relevant to what you're doing. So complying with the telemarketing sales rule, this is something that if you're interested in this, I would bookmark, because all of those questions that you have about, and let's see if they actually mention real estate agents. No, they don't. Maybe realtors. No. Anyway, they go through all of the different provisions of Do Not Call. And so a lot of those questions that you have, I think you could find answers in this as well. It also talks about the disclosures. Again, those are going to be for telemarketing campaigns where you're making the same calls time and time again, are the primarily important aspects of those. But every telemarketing call requires the who you are and the purpose of the telephone call. But I think that's a really helpful resource for companies.
This may be a silly question, but sorry. Go ahead.
Well, just to comment, one of the things, and obviously, Michelle, your context is much bigger than mine. But what I've been researching, it appears that the main traps for agents that are being set are around expired listings. Primarily, yes. About 90% would be around that, and maybe 10% would be around for sale by owners. And then, I think that's right. There's probably some other stuff out there, but those are the primary ones. Those are the trouble spots. Yeah,
I think that's right. And unfortunately, this is just a hot area right now as far as enforcement by class action plaintiffs' attorneys and regulators. So it's something we just need to be really careful about. There are ways that you can do it, and there's ways that you can do it safely. The types of things that cause problems are the pre-recorded messages, or hiring telemarketers without understanding the context of the calls that they're making, ringless voicemails, pre-recorded messages, all those types of things.
Yeah.
Yeah, okay. This is Michelle. I'm sorry, go ahead.
Michelle, great name.
Yeah, no doubt. So my question is, my business partner, who is another realtor there, and I used to do hundreds of calls a week. But what we did was we took our list and sent it to a company who scrubs against the do not call list. So I guess my question is, where does the liability stand? I mean, if they're scrubbing against the do not call list, why would that company ultimately not be responsible?
So the page I just showed you for signing up for the do not call list, to be able to download it, I told you it assigns you a subscription access number. So the requirement is that the seller scrub against the do not call list. So ultimately the violation is making the call without having a SAN and scrubbing against the do not call list. So if a company is using their do not call list and you don't have a subscription access number, then it's as if you haven't scrubbed against the do not call list. Now, having said that, because a company is scrubbing for you, the chances of an issue are very small. But the FTC has put out numerous statements about companies not sharing the do not call list with those that haven't registered. They don't earn money that way.
Michelle?
Yeah.
This is Debbie. I have a quick question. So you were talking about, let's say I have a buyer and they do run across a for sale by owner and they really want to see the house. Can I reach out to that for sale by owner and tell them I have a buyer?
Yeah.
Or is that?
Yeah, absolutely. No problem at all. I wouldn't consider that a telemarketing call because you're reaching out to buy something from them, not to sell them something. And that's the key distinction. Yeah, you can do that all day long.
Okay.
Those people will welcome those telephone calls.
Hey, Michelle, it's Dale. I have a question.
Sure.
Yeah, well, my question was, if people sign into my open house and they put their phone number down, do I have consent to call those people?
So I think you would have a good argument that they're making an inquiry by putting their name and their telephone number there. But if you really wanted to use a belt and suspender approach, you could put the consent language that I told you about, that, you know, you're by signing the registry, you're giving consent for me to call you about future listings, and that your consent is not required for purchase. Something of that effect, because you're not going to be using an ATDS. You're going to be making your own personal telephone calls. You're not going to be making pre-recorded messages. So you're just really worried about getting consent for do not call. And you could put a note up there.
Great feedback. Thanks.
Yeah, you're welcome.
Yes, my question was close to Michelle's. So if we hire a third party to facilitate this process and we are not registered with the do not call list, however, they are using our name or our company name to solicit, is that taking away the liability from us, or are we still liable if they do call someone that is not on the do not call registry?
Well, somebody who's on the do not call. Yeah. So, so the key element here is that you have a subscription access number. And so if once you have a subscription access number and you provide that to your marketers, what they do when they download the do not call registry, they have a mass entry field that they can put all of the subscription access numbers in that they're downloading that do not call list for. And so if you are less than 5 area codes, then you don't have to pay for it anyway. So I would recommend that you go ahead and register for the do not call list for the area codes that you need, get that subscription access number, and you can provide that to the marketer so that they're meeting the requirement to scrub against the do not call list before making telemarketing calls, non-exempt telemarketing calls that you don't have consent for. So that's how I would recommend handling that. But again, you know, when we're talking about high risk items, if somebody is registering against the do not call list, the risk is very small because you're not calling somebody who's on the do not call list. The risk is more for the telemarketer that's calling and is providing access to the list to people who haven't paid for it. Does that make sense?
Yes, thank you.
You're
Quick
welcome.
question, Chris. As a broker, like, what are your thoughts? I'm curious to hear, like, what are your thoughts on how to proceed, or what would you recommend?
Well, I, as I mentioned before, I think the expireds are the really tricky thing to watch for. I would not do anything automated with expireds, and I would always scrub them with the do not call list. And that's going to take some people out of their game. But I would say 90% of our agents really aren't going after expireds, and so it's probably not going to affect the most. But if you contact expireds, then you've got to play by those rules. And then the same thing with for sale by owners. So I think the big picture is if you're not working those channels of business, I would be really focusing on sphere of influence. I'd be looking at marketing, marketing to get them to call you. Like you can take those lists, those phone numbers, and you can run a Facebook ads campaign that only shows to those people with those phone numbers. So I'd be looking at some creative ways to get to them that's not using their phone, at least as far as calling. But I'd be looking at ad campaigns and things like that. So, and then look for other channels. There's lots and lots of different ways to generate leads. Go through. We have eight different lead generation, lead provider companies that we partner with. I'd be doing that. Just any other way you can get those 300 leads per month or whatever it is you're looking for.
Great advice. Well, I'm available if anybody has any questions. And Chris, it's been a pleasure working with you. I'm sad that it's under the context that it's been, but hopefully we've saved other people from running into these types of problems, and that, we don't want to stop you from advertising. We just want you to stop and think before you advertise using the telephone.
Yeah. Thank you. Thank you for your time. Great content.
You're welcome. I was happy to do it for you.
This. We should have done this 2 years ago, and that would have been a lot cheaper lesson, but
you're on our newsletter now.
That's great.
All right.
Well,
take care, guys. Good luck, everybody. Bye-bye.
All right. Bye.